Good afternoon. All right, I'm just gonna wait one more minute to see if anybody else is gonna sign on today, and then we'll just dive in. As a reminder, your midterm is due today at midnight. Again, I'm taking everything late this semester, so if you don't get it done by midnight, just submit it whenever. But do get that in because that's a big chunk of your grade for the semester.
I have a weird question.
Okay.
So for the midterm itself, I know I've been going back and forth between two different ways to do it, but is it okay if we just kind of do a paragraph itself for each question and incorporate each? Okay.
Yep, and in fact, that's what I'd probably recommend. It's just like question, answer, question, answer. It makes it easier for me to grade. Okay. Then you make sure you don't miss any piece. So.
Okay, so I didn't do it where it was like I put an answer for 1A, 1B. I just kind of did an answer all together as one.
That's fine as long as it's clear that all the pieces are answered.
Okay, got it. Thank you.
Yep. Good question. Yeah, either works. Just if you're combining them, make sure that you are giving an adequate response for each piece. Remember, sort of think about our group assignment questions being worth 2 points, and then think about what a 5-point answer is compared to that. So it's a good metric. All righty. Well, I'm going to go ahead and share screen. Okie dokie. So we were talking about NGRI pleas and sort of the actual versus what people think. And so the only thing I'm not sure if I did well, just because it was right at the end, was to talk about what plea bargaining actually is. So this can happen in any case. Doesn't have to necessarily be one where not guilty by reason of insanity is being raised. But when you plea bargain, you essentially enter a plea and it just doesn't go to court. So if you plead guilty, then it would maybe never go to trial, right? Or maybe you come up with a plea bargain where you kind of decide on your sentence, or basically maybe the prosecution says you won't even be charged with this if you turn in someone else or provide us information. So if you're entering a plea for NGRI, then you'll get the psych eval, you'll get that referral for evaluation of criminal responsibility, and then you'll get some resolution without a trial and basically everyone agrees that that person met criteria for insanity at the time of the act, based on that report. The other thing that can happen is you can plead guilty to a lesser charge, with treatment instead of jail. So maybe you, plead guilty to manslaughter instead of murder, and you go to one of those facilities, the criminal psychiatric facilities, rather than going to prison. So how has this changed over time? Well, there's been a lot, as you can tell just from like the number of bullet points on this slide. And the funny thing is, as we go through this, is you'll hear that like there are still places that use some of these really old school ones. Okay, so it'll be sort of interesting to hear about them. So one thing I always have to note is that the reason I have insanity in air quotes here is that insane or insanity are legal terms. They are not psychological terms. So if you open the DSM, which is the Diagnostic and Statistical Manual of Mental Disorders, nowhere in there is there going to be a section for insanity with specific criteria, right? So that's something that's really important to note, is that this is not a psychological diagnosis that you can be given. Sorry, I just realized the chat isn't up. So I'm putting that up in case anybody wants to put any questions or comments there. So based on that, the legal system has had to define what insanity is throughout history. And so these are some of the ways it has been defined. So the wild beast test was the first one. And the idea here is you're not responsible for your actions at the time of the crime if you had no more control over your behavior than a wild beast. That's the actual definition. That's what they used back then. Very vague, right? Like what kind of wild beast? Like dolphins could probably figure some shiz out. I don't know about all the other animals, right? So that was one that was used. Clearly we came up with other things. The McNaughton test is actually one that's still used in some municipalities. So this came from the case of a man who suffered delusions and killed the secretary of the British Prime Minister while attempting to kill the Prime Minister himself. So this person wasn't like, I'll go get their secretary, that'll get them. They were trying to kill the British Prime Minister and in fact killed the secretary in the process. So the McNaughton test is the standard of knowing right from wrong at the time of the crime. So this states that if people are legally insane at the time they committed a crime, if, because of a mental disorder, they did not know the nature of the act, basically didn't know what they were doing, or didn't know right from wrong, that's the two, or didn't know right from wrong. So again, the idea here is at the time of the crime, not now. Now doesn't matter, which sounds weird, but it doesn't, right? Because remember, this person could have gotten treatment between the crime and now. There's a lot that could have gone on. So with your psychological detective work, at the time of the crime, maybe months or years ago, did this person know what they were doing, know the nature of the act, and or did they know right from wrong? Did they know what they were doing was wrong? So this test is still used in all cases tried in federal court and in 28 states. So even though this is an older rule, it's simple. It kind of goes with what the insanity defense is getting at. So this is still used quite a bit. The broader rule stemmed from the Moral Penal Code. This rule states that a defendant is not responsible for criminal conduct if he, and this is a big long quote, so bear with me while I read it. If he, at the time of such conduct as a result of mental disease or defect, lacked substantial capacity either to appreciate the criminality, wrongfulness of his conduct, or to conform his conduct to the requirements of the law. So it's kind of just a wordier version of the McNaughton rule, right? But this specific rule is used in 14 states. So again, to break that down, it is essentially at the time of the crime, they either can't figure out that this is criminal, wrong, or can't conform to the law because of a mental illness. And that's the caveat here. The irresistible impulse test emphasized the inability to control one's actions. So you were insane if you commit a crime in an uncontrollable fit of passion. Again, define that one, right? That one gets tricky. The Durham test comes from a U.S. Supreme Court case, Durham v. U.S. From 1954. So this is good old Judge Basildon, who we've talked about before. Good psychological ally, mental health-oriented judge. So he allowed a psychologist to testify. As we talked about earlier in the semester, he said, yeah, psychologists have the knowledge to be an expert witness. And to establish not guilty by reason of insanity, you had to show the person had some mental disease or defect. And then show the criminal act as a product of that. So the Durham test is 1, show that they actually have a diagnosis, essentially, some mental disease or defect. And 2, show that the criminal act is the result of that mental act. Because you can have a mental disorder and it doesn't cause you crime, right? So again, show the relation between the two. This was later refined in a couple different cases. One was McDonald versus U.S. And in that case, they said you need to prove you're substantially impaired because of the disease or defect. And you're, again, not just excused because you have one. And then in this U.S., no, sorry, that's supposed to be versus Browner case, not Warner, Browner case in 72, they basically threw the Durham test out the window and they went back to the Monotony test. They were essentially like, this makes things too complicated. You don't have to have a psychological diagnosis. You just have to not know the difference between right and wrong at the time of the crime. The American Law Institute test says people are not criminally responsible if, again, at the time of the crime, they had a mental disorder or defect that prevented them from knowing right from wrong, or being able to control themselves and follow the law. So this is like kind of a mash together, right, of Monotony and Durham and irresistible impulse. And this was a response to a call for tougher standards after the John Hinckley Jr. case that I talked about on Tuesday, the man who shot President Reagan. And so that's what we'll talk about next, is this U.S. v. Hinckley case from 1982. So again, he attempted to assassinate President Reagan to impress the actress Jodie Foster, which, like, since then, Jodie Foster's actually come out that she's a lesbian. So, you know, that wasn't public knowledge back then, but even more so, right? This wasn't going to work. He was actually stalking Jodie Foster. So there's another crime in and of itself, right? And he was found not guilty by reason of insanity, had that criminal commitment, again, only got out a few years ago. So served at least 30 years in that facility up in Williamsburg. And it sparked outrage around the nation because he was found not guilty. That's what people thought, is like, not guilty by reason of insanity just meant, you know, not guilty. So he got off. And in fact, that's, like, as we talked about, not really the case. So this is what started that call for stricter standards for this defense. Yeah, a big goof, definitely. Yeah. The National Defense Reform Act in 1984 said that you needed a severe mental disease, crime had to be the result of it, and then you had to not know the nature or quality of the wrongness. And then it sort of actually just went back to Midnaughton, essentially. And the burden of proof for NGRI is now on the defendant. So that wasn't really clear before, or they thought maybe you had to just like a prosecutor has to prove someone is guilty. They have to prove they're not guilty by reason of insanity. Now that's on the defendant. If you're going to make this plea, it's on you and your legal team to show this, right? And again, the expert report that you will get from your assessment. This National Defense Reform Act also codified into law what Basildon had been doing and said that it established the equality of psychologists and psychiatrists as expert witnesses. Again, even though PhDs have been the OG doctors forever, right? In our modern society, we have taken the word doctor just to mean medical doctor. And that has been given more prestige, even though sometimes PhDs have more training. Anyway, I'm biased. I have a PhD, fully admit, right? Do not want to diss MDs at all. They are amazing. We need them. They are on the front lines, right? Just basically, now it says we can both serve as expert witnesses. In my opinion, that's the way it should be, so that's good. And then the American Psychiatric Association recommendation. So this is the body that publishes the DSM. It's a body made up of psychiatrists, of MDs. So they say that you should find people not guilty by reason of insanity only if they don't know right from wrong at the time of the crime. They said, you know, the inability to control themselves, that irresistible impulse test shouldn't matter. Inability to follow the law shouldn't be sufficient. And again, back to McNaughton. We keep throwing it back to McNaughton. And again, that's still used by all federal courts and 28 of the state courts. So we keep throwing it back. Now, sidestepping out of our lecture for today, this shiz may come up in the case, and it's sort of already being raised, in the case of the white nationalist terrorist who killed 6 Asian people and 2 people of other descent in Atlanta recently. And I choose those words very specifically. The officer who made the press conference tried to claim this man had a sex addiction, and that's why he did it, and he just had a bad day. I can't. Sex addiction is not technically a diagnosis in the DSM. There are some who argue it should be, so that's neither here nor there. 2 is that probably, even if it was, wouldn't meet the criteria of NGRI. He probably knew this was against the law at the time, right? But he thought he could get away with it because he was killing people that he felt were lesser than him. And he's claiming it's not racist. I don't think we should allow racists to decide whether or not something is racially motivated. The fact that his sexual fetish seems to revolve around Asian women is not only sexist, but misogynist, and very problematic. And so, again, without knowing the full facts of the case, but just having spent a lot of time on Twitter yesterday and reading articles about it, because I was laid up by my second COVID vaccine. The side effects the second time are real, y'all. I just want to say, like, I stand in solidarity with the Asian community. I think if this guy tries to use an NGRI defense, that's BS. He is just a terrorist who went and committed mass murder. And it was a hate crime and should be tried as such. So, and that's all I'm going to say about that. So, who are the people that are actually found not guilty by reason of insanity? You know, again, it's a very small percent of criminals, right? What do they have in common? 2/3 of them are schizophrenic. And for those of you who haven't had the chance to take something like abnormal psych, schizophrenia has like really weird definitions in our media. So you'll have movies like Me, Myself, and Irene that claims that Jim Carrey has schizophrenia when actually what they're showing is what used to be called multiple personality disorder. It is now called dissociative identity disorder. So let me just break down real quick for you what schizophrenia actually is. So schizophrenia is a disorder of psychosis. Psychosis in and of itself is like getting a fever. There's a whole bunch of different reasons you could have psychosis. Just like there's a whole bunch of different reasons you could have a fever, right? You could have the flu, you have a urinary tract infection, you could have just gotten your second COVID vaccine like me yesterday. So same thing with psychosis. Like you can have psychotic symptoms because of drugs or alcohol or, you know, also a UTI actually, or, you know, because you have schizophrenia. Schizophrenia, you have to have at least one symptom that's either delusions, hallucinations, or disorganization. So delusions are fixed false beliefs. So John Hinckley Jr.'s belief that he would impress Jodie Foster by shooting President Reagan is an example, okay? They do not make sense. There was a young man who came into our clinic, our training clinic when I was assistant director, and he told me that the CIA had been following him across 3 states, but they had stopped, so that really meant something. That's another example of a delusion. Hallucinations are sensory, so hearing, seeing, smelling, tasting, touching, feeling, rather, something that's not there. Typically, in cases like this, it would be seeing and hearing voices telling you to do things, for example. And then disorganized thought and speech can manifest in a whole host of ways. There are also negative symptoms of schizophrenia that can look a lot like depression or can go even more extreme to catatonia, where you can just hold poses all day and not move. So it's a very, very severe psychological disorder. It's also really rare, right? And we still don't fully understand it. There was a study that came out, I want to say like 2014, that showed that schizophrenia might actually be like 6 or 10 distinct genetic things. So there's definitely something there. Yes, yeah, the robots in the park in the city, the ones who pretend to be statues. Yes, Naila, it's exactly like that, actually. The waxy flexibility that can be part of catatonia is they'll just hold poses. And then it's kind of like, this is really dating me, but a Gumby doll or like other bendable dolls, you can actually like move their limbs for them. It's very strange. And again, very rare, right? And typically it's the delusions and the hallucinations that are to drive something like this. About half of the people who use the NGRI defense successfully are Caucasian. This, of course, does not match at all with the criminal justice system. I don't necessarily think this means that white people are crazier, although it might, I don't know, right? I think what it means is that Caucasian people are more likely to have access to better legal resources and perhaps a legal team who might recommend trying this to them. 86% are male. We just know that more violent and severe crime is conducted by males. It's certainly not exclusive to males. We know of female serial killers, for example. But I think that that's a big proportion of this. It has to do with the social acceptability and the general socialization of like how even you act illegally, right? If you're male versus female. So I think that's a piece of it. Their mean age is 32. So sort of young-ish, but not, we're not looking at like, 18, 22-year-olds. Okay, so let's say you're a psychologist and you get sent a referral for an NGRI evaluation. What do you actually have to do? Well, in some ways, this is going to be somewhat similar to what we talked about on Tuesday for whether they're competent to stand trial. So a big thing you're going to do is go through records. And this is going to be even more important in an NGRI case because remember, we have to do psychological detective work, because now we have to figure out this person's mental state at the time of the crime. And that is really tricky. To be perfectly honest, we don't have good instruments that can just do that for us. So a lot of this becomes doing detective work. And in fact, one thing I'll just say in general is assessment in general is kind of like putting together a puzzle. I knew nothing about assessment before I went to grad school. We took a lot of assessment classes. I think probably most clinical people do, but Kent State is very assessment focused. So I probably got more than usual. And I ended up loving assessment. I even like took a neuropsychological assessment practicum when I didn't have to, because it is just like kind of solving a mystery, figuring out what's going on with this person, taking all this information you have and integrating it. And you have to do that sort of to the nth degree for this type of case. So in terms of records, you know, you're going to get what's relevant. You know, if school records are relevant, you might get those. Criminal history, the police reports at the time of the crime, especially because they can provide an account of the behavior of that person close to the time of the crime. And obviously, if they have previous psychiatric records, you want those. Then you're going to do an interview, but you're not just going to interview the defendant. Certainly you need to interview the defendant. That's probably the most important. But then you want to interview everyone else around the defendant. So their family members or close friends. If the victim is alive, right? If it's not a crime where the victim was killed, you want to interview the victim, any witnesses, fellow coworkers can be a big thing as well. Neighbors, although neighbors don't always have it. I feel like every time there's a neighbor on the news when someone's committed a horrible crime, they're like, he was just such a nice guy, right? And you're like, oh boy. But if they're particularly close to their neighbor, they may have some insight, or they might just be able to tell you about their comings and goings. You want to especially interview those whom they may have interacted with on the day of the crime. So if they went to work that day, you want to make sure you interview the coworkers. What were they like that day? And they might not remember, right? But one of the things that happens when there's something really traumatic that happens, like your coworker commits a heinous crime, is you can get what's called a flashbulb memory. It's often reserved for huge, large-scale traumatic events, but essentially you remember more detail about that day because you paid special note because something incredible happened that day, right? Like I remember almost minute by minute, maybe not, but like hour by hour what I did on September 11, 2001. Could not tell you hour by hour for any other day of my college career. Then you want to do some traditional assessment, some psychological tests, but keeping in mind that these are only going to tell you what's going on with that person when you're evaluating them right now. So the WAIS has recommended that Wechsler Adult Intelligence Scale, again, this is the gold standard for intelligence scales. It also has really good retest reliability. So if you give this to someone at one time and then another time, it is very, very likely to essentially give you the same score. The retest reliability for this instrument is 0.95 out of a possible 1. So that is very, very stable. So this will give you an insight into whether they have any sort of intelligence issues or specific issues as well. And then the MMPI-2 is also recommended. It can identify people who are malingering because of those validity scales we've talked about before. So people who are trying to fake to get out of, to end up in a mental facility, you can catch them with this usually. But again, it will only tell you about now. It won't tell you about their mental state at the time of the crime. However, if they're not malingering, but they do have a serious psychological disturbance, that's really helpful. So if they're showing up with like symptoms of paranoid schizophrenia, that is another thing that's pretty stable over time. Like that's not a disorder that just sort of goes away on its own. So if you're seeing symptoms of that now, that's a fairly good indication they could have existed then as well. Then there are assessment instruments that are NGRI specific. So they've been developed specifically for these type of evaluations. So the most commonly used one is the Rogers Criminal Responsibility Assessment Scales, or RCRAS. Again, psychologists love a good acronym. Here the clinician provides the data based on everything we've just talked about, the records, the interview, the traditional assessment. And there's 25 scales, each is one item, and you use it to rate different aspects of their behavior, and then you condense it into subscales. So there's a subscale for malingering. There's a subscale for organic disorders. So is it something like a head injury, or do they have a developmental delay or an intellectual disability? Major disorder. Cognitive control, which really gets at that question you need to answer in most situations, which is knowing right from wrong. And then behavioral control. It's really useful for organizing data and serves as a guideline for data collection to make sure you're hitting all these items. But Jack Graham, who again taught me this class, is an MMPI, total expert, referred to this as pseudoscience. He said, it's not really that scientific, it's just a really nice organizational structure. You're making ratings, and then it's sort of a decision tree. So I'll just give you that caveat that Jack gave me. And then based on the decision tree, there's sort of 3 outcomes: sane, insane, or no opinion. One of the reasons why Jack called this pseudoscience is because it's the psychometrics, its reliability and validity are all over the board. So if you have one person and a second person look at the exact same data, you want that to be really highly correlated, right? You want that to be, at least 0.7, like 70% of the information they agree on. For this measure, it ranges from 0.45, so only 45% agreement, up to 1, so 100% agreement. That's really problematic, right? So again, it's a nice decision-making tool and guidance to make sure you get all your data, but you really want to be using your clinical skills and your training as you do this over and above this assessment. So in terms of how do you write up this report if you are one of these folks? Well, first thing you're going to do is say, who gave you this referral? Right? Was it the lawyer? Was it the court? Was it the prosecutor's office? You want to talk about informed consent and confidentiality. Say that you discussed with the defendant, what this entailed and who could get the information, their attorney, the judge, right? And knowing that information, the defendant agreed to participate. Then you have your sources of information, and here you would list all the tests you gave, but then also all the other sources of information, so who all you interviewed, the police reports, all those records that you looked at, each of those would get listed. And then you're going to talk about their history. So you're going to talk about their social history, their medical history, particularly as it relates to their mental health history, substance abuse history, and legal history, right? So you want to talk about past run-ins with the law, past diagnosis, past treatment, all those kinds of things. Then you want to talk about their mental status at the time of evaluation. Did they seem to know where they were and why they were there? Were they dressed somewhat coherently? Did they look like they were taking care of basic hygiene? What was their affect like as you talked to them? Then you talk about their behavior in jail, right? So one of the people you want to interview is, maybe the superintendent or, the guards that interact with this person, has there been any particular thing? So in my abnormal psych class, they look at case studies, and for the guy with schizophrenia, he is in jail, and he's like throwing his tray at the TV because he thinks it's trying to give him messages and things like that, right? Like that is not ordinary, but it's not out of the question for someone who might be coming up for NGRI. And then you want the defendant's count of their alleged crime, before it, during it, and after it. So do they seem to know what happened? How do they explain it, right? And then interpretation of the data, of all the stuff you've gotten. And you want to include whether or not you think this person could be malingering or faking. And then you give your opinions about their mental status at the time of the offense. Usually, just like with NST or IST, incompetence to stand trial, we are not allowed to give an opinion on the ultimate issue. So you can't say, yes, this person is not guilty by reason of insanity, but you are giving an explanation that gets at helping the judge make that decision. So this is the most important part. You want to say whether or not that act, that offense, that crime, again, that happened months or years ago, is related to their mental status at the time. Did they know right from wrong at the time of the crime? Did they know what they were doing, the nature of the act at the time of the crime? So did they understand what they were doing? Did they know it was wrong? Again, at the time of the crime. And again, just like with any other report you're sending, you want every sentence to be impeccable, every sentence to be unimpeachable if it were to be questioned in the court of law. So here are some famous insanity defense cases in addition to Hinckley. So David, some of Sam Berkovitz, there have been movies about him and whatnot. So he was a serial killer in New York City. And he said that a barking dog was sending him messages to kill people. So he was trying to argue he was psychotic. And he was found guilty, even though two psychiatrists did diagnose him as psychotic. And it's important that he was found guilty because he later said he just made up those delusions and hallucinations about the dog. Like, he just was trying to get out of things. Andrea Gates is another case, very, very sad case. I actually got the chance to see a grand rounds by one of the psychologists that assessed her. So learned a lot of details about her case while I was in graduate school. So she actually drowned her children, and she had a history of postpartum depression and other postpartum disorders. And the child she had prior to the one she had just had when she committed her crime, her doctors had told her and her husband, like, you can't have any more kids. She can't keep going through this. But it's unclear whether she was actually part of this, but certainly her husband was part of a religious sect that believed that you should just have as many children as God would give you. And so he refused to use birth control or let her have a tubal or anything like that. So when she had this new child and she experienced postpartum depression, it sounds like also postpartum psychosis, that's when she drowned her children. So this is especially frustrating because it was preventable, right? And she was clearly crying out for help. The first trial, she was found to have a mental disorder, but still found guilty. But then there was a retrial in 2006, and she was found NGRI, not guilty by reason of insanity. Now, again, this doesn't mean she is off scot-free. She is in a maximum security state mental institution, again, probably for at least 30 years. Defendants who are found not guilty by reason of insanity, in addition to some of those other things we've already talked about, typically have a record of prior arrests or convictions, although that doesn't necessarily exceed the rate of other felons or, other repeat offenders. They tend to come from lower socioeconomic backgrounds, lower socioeconomic status, or SES. There's a whole host of reasons. This doesn't necessarily have to be causal. We know that, for example, people who have schizophrenia actually are more likely to do less well off than their parents, which is rare. Although certainly millennials and Gen Z may face the same fate because of the economy. It can also be that, again, if you are lower SES, maybe you just don't have access to the care you need if you do suffer from one of these disorders. They often have a prior history of psychiatric hospitalizations or just treatment in general. And they often have previously been found incompetent to stand trial in another case. So again, we see these things happen over and over. All right, so NGRI, in theory, should be great, should protect those who, were mentally ill, but also still protect society by putting them in facilities where they're, in theory, going to get help and cannot re-perpetuate those crimes. But obviously, there are some problems. So the biggest one is what you've heard me sort of talk about back and forth here already. There's a fundamental difference between the law and the science of human behavior, in particular, psychology and psychiatry. So the law assumes that individuals have free will and are generally responsible for their actions. However, clinical behavioral research supports the notion that psychological and physical forces affect human behavior, right? That you don't always solely have free will. And people may not be able to control their behavior as much as the law portrays. Another big piece of this is the uncertainty of scientific knowledge about abnormal behavior. Psychology, in the grand scheme of things, is a very young science. It only started in the late 1800s. Most sciences, if you think of biology, chemistry, physics, right, have been studied really since ancient times, if not since Middle Ages, Renaissance, that type of thing. So during a typical insanity defense trial, the testimony of the defense clinicians will differ from the testimony of clinicians hired by the prosecutors. So the jury has to weigh the claims of these two different experts who disagree in their assessments. Some people see this lack of agreement as evidence that clinical knowledge in some areas may be too incomplete to be allowed to influence important legal decisions. And a lot of it just has to do with the uncertainty of our science, right? That we're still discovering things all the time. One of the most often heard criticisms, which we've talked about here, is that the insanity defense allows criminals to escape punishment. I think that it's arguable, right? Because they don't just go scot-free, they do go to these criminal lockdown facilities. And there's also the problem of time. Psychologists and psychiatrists, again, are asked to determine if people were insane at the time of the crime, months or years earlier. And it's very difficult to determine, and we don't really have assessments that measure that well. There are now other similar verdicts that can be used besides NGRI. So one is guilty but mentally ill. And this is a verdict stating that defendants are guilty of committing a crime, but they're also suffering from a mental illness that should be treated during their imprisonment. This is not a substitution for NGRI, and it is controversial in and of itself. Basically, it says, yeah, they have a diagnosis, they have a mental disorder, but that's not why they committed the crime. They're still responsible. Guilty with diminished capacity. Here, a defendant's mental dysfunction is viewed as an extenuating circumstance that the court should take into consideration in determining the precise crime of which he or she is guilty. For example, a defense attorney could argue that their client, as a result of mental dysfunction, could not have intended to commit that crime, could not have planned it. So then they could be found guilty of a lesser crime, like manslaughter, instead of first-degree murder. Then there's also a verdict that can be given that's mentally disordered sex offenders. So they would be convicted of a criminal offense and responsible for their actions. And then they're committed to mental health facilities like someone with NGRI. So it's a criminal commitment. And this reflects the belief that sex offenders are psychologically disturbed. It's also to protect sex offenders because of the abuse they receive from other inmates in prison. So if you're not familiar, particularly if someone is a pedophile, even other felons don't like people who are sex offenders a lot of the time. So they will be sexually assaulted themselves or even killed while they're in prison. And so this was sort of a avoiding cruel and unusual punishment measure for that reason, right? They haven't been sentenced to death. States have been getting rid of this because it's difficult to apply it. To be perfectly honest, it's really hard to treat someone with pedophilia. A lot of times they don't understand there's anything wrong with it. And then more and more society is less concerned about the rights and needs of sex offenders due to public outreach. So it's sort of becoming less en vogue if you take that. All right, so what are some of the other ways psychologists could be asked to come in and do an assessment during a criminal trial? Well, one is a risk assessment. So a risk assessment is an evaluation of the likelihood this person will be violent in the future toward other people. So if we were to let this person out on bond or put them on parole, what is the likelihood that they will be violent towards someone else again? And a couple court cases are pertinent here. So Barefoot versus Estelle in 1983 permitted the introduction of mitigating circumstances and said that psychiatrists could testify about the likelihood of future violence. And this was the first time anyone was clearly allowed to testify about future violence. This can be a huge factor in death penalty evaluations, where you would talk about, well, this person's never going to be reformed, yada, yada, yada. Or you would say, I think this person isn't likely to do it again. This isn't very accurate, maybe not surprisingly, but there still can be testimony about it. Shell v. Martin in 1984 rejected the contention that it was impossible to predict future behavior and used it in the context of a bail situation. So they used professional testimony considering future violence in a pretrial hearing, and the court said that was okay. And then Kansas v. Hendricks in 1997 said you can use this type of risk assessment to help determine civil commitment. So again, when someone has to be committed to one of those civil institutions, and also prediction of sexual violence, so not just physical violence. Overall, these cases show a belief that experts have the ability to testify concerning future prediction of violence. So when? We always do this in normal clinical practice. Someone comes to you, some of the first questions you ask in the intake once you've established rapport are, about suicidal ideation and homicidal ideation. You want to make sure that they are not a threat to themselves or other people before you let them leave your office. If they are, you try to contract for safety with them. If they won't contract for safety, you involuntarily hospitalize them. Death penalty cases, that's going to be used by either the defense or the prosecution. Civil commitment, this is actually one of the criteria for civil commitment, dangerousness to yourself or others. Pre-trial detention, again, kind of thinking about bond. Do we keep this person in or do we let them go? Pre-sentencing evaluations. Will there be repeated violence? And this is usually whenever a crime involves violent behavior. And whenever there's a question of releasing people, whether it's on parole or whether it is from civil commitment, you would have a mental health professional do a risk assessment. And the core of all this is the protection of society. That's why we're doing it. So the Tarasoff case that we talked about in our activity at the beginning of the semester is obviously very relevant here, right? So not only do we want to ensure the safety of the public, but if there's anyone who is at risk, we should notify them. So how do we make these predictions of future violence? Well, there's two different ways. One is a clinical prediction, and this is a judgment made by a clinician using things that are informed by research. So we would use things like the psychopathy checklist, or psychopathy, there we go. And this is really the only thing that's really recommended for these things. But you could use the MMPI-2, the WACE, the PAI, a screening version of PCL, but none of those are specifically going to get at that question of violence in the same way that the PCLR will. There's also what they call the actuarial or statistical prediction. And this is based on data and research, and you use decision trees. And if you're not familiar with what actuarial science is, oftentimes this is involved in like insurance processes. So based on, your medical data, how long are you supposed to live? How much should we charge you for health insurance or life insurance? So Grove et al. In 2000 found that actuarial prediction is more accurate than clinical prediction by about 10%. But if we're talking about risk for violence, right, we probably want to be as accurate as we can. There is the MacArthur Violence Risk Assessment Study. And what they said here, and maybe not surprisingly, is the best prediction of future violence is past violence. In general, in psychology, we know the best prediction of future behavior is past behavior. And they use a decision tree to put people into categories. So there are 5 different categories ranging from lowest risk to highest risk. And it's a good classification. So when you put people in the lowest category, only 1% of them engaged in violence later. But the highest category, 76% of them engaged in violence later. So this is pretty accurate if you use this method. All right, malingering. We've talked about this quite a lot in passing as part of the other types of evals, but you might be asked to look for this specifically. So malingering is the intentional fabrication of or exaggeration of physical or psychological symptoms. So you're either fabricating, totally making up, or exaggerating your symptoms, and it's motivated by extrinsic incentives. Like you don't want to go to jail, or it could be, in a civil case, something like trying to get money for your lawsuit. So malingering seems to occur about 15 to 17% of the time, 15 to 17, not 50. And it could be higher in some settings. So for example, it's about 41% for NGRI evaluations. But you have a big motivation, right, to malinger there. So one of the things that can happen is malingering can be coached. So they can be told to respond by an attorney or even a consultant who is purportedly a mental health professional, but clearly violating their ethics. And so Wetter and Corgett in 1995 did a study, and they found that 50%, so a full half of attorneys and 40% of law students felt it was not only okay, but their responsibility to give their clients information about the tests and how to avoid being detected if they are malingering. So this is really problematic because they'll tell you how to answer the Rorschach or the MMPI, and this really compromises test security. How do we detect it? How do we figure out malingering? Well, one of the things we look for are rare symptoms that even people who are psychiatric patients, inpatient hospitalized with severe mental disorders, don't endorse. And there are actually scales built into things like the MMPI that look for things like that. Improbable, probably, on here, symptoms are those with a preposterous quality. They're completely off the realm, or maybe, there's just too many of them. Then the symptoms combinations. So like, yeah, I'm experiencing grandiosity and I feel like I need to sleep all the time. Like that doesn't make sense. You're now describing like manic symptoms and depressive symptoms, right? Symptoms of severity and distress. So people who are psychotic, not always, but usually are not distressed by their strange symptoms. And in fact, in some cases, they find their psychosis comforting in some way. Like those voices become friendly. So if this person is distressed by it, it doesn't mean they're not psychotic. It just means that's something we need to consider. Indiscriminate symptom endorsement, so just endorsing everything. Yep, I got that, and I got that, and I got that, and I got that. All right, they're clearly just like trying to check every box. Obvious versus subtle endorsement. So they might only endorse obvious symptoms, but miss the subtle ones that go with that disorder. So like for psychosis, like schizophrenia, yeah, you have the delusions and hallucinations, but you also might have flat affect as part of your negative symptoms. And they might not endorse that because it's not obvious. Most people who are mentally ill don't really want to talk about it. This is one of the reasons why a lot of people who are mentally ill don't seek psychological care. So it's a red flag if that person seems really eager to talk about their symptoms. So another thing you want to look at is reported versus observed symptoms. So if they're saying one thing, but then they're acting a totally different way, what are you seeing in your behavioral assessment? There's no single perfect strategy. And the other thing you have to look for is cognitive malingering. So they might be saying, oh, I have a head injury and that's why I did this, right? Intelligence, memory. You have to look for, again, excessive impairment, doing worse than chance on tests, deliberately choosing the wrong items, or looking for unexpected patterns where they'll do horribly on the easy items, but better on the harder ones. Like that doesn't happen in someone who actually has cognitive deficits. And there are also measures you can use specifically to find malingering. And so I've mentioned the MMPI-2 having those validity scales. So there's the F, the FB, and the FP. And these are all infrequency scales. So when people malinger, they endorse these symptoms that are not even endorsed by people who have severe psychological disorders. So Storm and Graham studied 3 groups. They had students who they said, just take the MMPI, just take it normally. They had students who were instructed to malinger and coached on how to malinger. And then psychiatric patients who they just said, just take the MMPI. And what they found is that people who are uncoached, the MMPI does really well, works really well. But if they're coached, you have to actually use lower cutoffs because they're going to endorse fewer of these extreme symptoms because they've been given tips on how to avoid them. So there can be 2 types of coached malingering. One is for the symptoms themselves, so for a specific disorder, and then you can actually coach to the specific validity scale on the test. So if you're given information about the disorder, your score is, you're going to score more like an actual patient than those who are not coached. But that won't affect the ability of the validity scales to detect that you're malingering. If you're coached about the malingering, about the validity scales, that makes it obviously much more tricky to catch it. The SEERS is the structured interview of reported symptoms, and that is developed to assess feigning malingering. I love how we have different words for it. It takes about an hour to give it. and it's based on strategy specifically for identifying malingering. The classification rates are greater than 90% in just about all cases. That's really, really, really good. However, it's not practical in routine forensic work because it does take so long, right? It also doesn't have, sorry, that was for something else. It does give additional support. If you're doing something else or you're giving the MMPI, it looks like, ooh, there might be some malingering, then you might follow up with the SEERS. The MFAST is the Miller Forensic Assessment of Symptoms Task. So I'll say that again. Miller Forensic Assessment of Symptoms Task, MFAST. So this is a shortened test that uses the same detection strategies used by the SEERS. But there's only 25 items, so it only takes 5 to 10 minutes in a structured interview. This is newer, so it doesn't have as much support as the SEERS. And it's better at ruling out malingering than proving it. At best, it should be seen as a screening measure, and then you would give the SEERS or the MMPI if you weren't already planning to do so. The Portland Digit Recognition Test is one of the things you can use to test for cognitive malingering. So malingering in terms of a head injury, memory problem, what have you. So you present a 5-digit number, then a distractor, and then you choose the number from a pair. And this seems difficult, but we're pretty good as humans at recognition. So as people score worse on this, it's more likely they're faking. A similar test is the test of memory malingering, or the TOM, which was developed, I'm not joking, by a guy whose name is Tom Tombaugh. Just like you can't make some of this stuff up. All right, so Tom Tombaugh developed the TOM, and it is 3 flip books, and you show the person 50 pictures for 3 seconds each, and then you go through the flip books and you ask them which one they've seen before, and they choose from a pair. Just like the digit recognition test, humans are really good at this. Humans are really good at recognition, particularly for pictures. I mean, you could even argue it was like evolutionarily helpful, right? To be able to like recognize that's a lion, so I have to stay away from it. That's a giraffe. It's probably okay if I go a little closer, right? So, in actuality, most people get close to 100%. I gave this to every person that I gave a neuropsychological assessment to during my neuropsych practicum. And typically they'd only miss 1 or 2. Like it was rare to miss more than that. I had one guy who did score where he missed, quite a few of them. And he wasn't malingering. What actually happened in his case is he was so depressed that he couldn't give adequate effort on the test. And so it wasn't that he was trying not to remember. It was just he couldn't remember just because he wasn't paying attention. So we actually referred him for therapy. He was in therapy for a while, came back, and then we were able to get an accurate assessment. And again, that's where your clinical skills can come into play and help you determine what's really going on here. All right, what about juvenile transfer? So forensic psychologists sometimes evaluate youth whose criminal cases are being considered for transfer to adult court. So this is someone 15, 16 years old, and they're thinking of trying them as an adult. Those evaluating juveniles for a possible transfer must focus on the risk of future offending, the interventions that would be needed to reduce that risk, and the likelihood that they would actually respond favorably to those interventions or they give it. States vary in the specification of the age at which an adolescent is eligible for prosecution in the criminal system. Most still use the age of 14 or 15. But again, like thinking that 18 is the adult cutoff in most places, we're still talking about trying a freshman in high school like they were an adult, right? So we want to be really sure. There are several justifications for transfer into the criminal system. One, if you're charged with homicide, right? That's a violent enough crime. We don't want you repeating that, right? If you're charged with other specific violent felonies such as sexual assault, or if you have a history of prior juvenile offending, like the juvenile system clearly is just not working for you. Juveniles can be transferred to criminal court, adult criminal court, in various ways. So statutory exclusion is where the state legislature can determine that certain offenses must be filed directly in adult court. So here you wouldn't have to do an assessment, right? Because we're trying a homicide, it has to go to adult court. Judicial discretion is where juvenile court can decide whether the youth should be transferred to adult criminal court. And then prosecutorial discretion is where prosecutors can decide whether cases are to be filed initially in juvenile or adult court. That would be up to the prosecutor to decide, again, given the law within their jurisdiction. Is putting juveniles in the adult system actually effective at reducing reoffending? Because that's the idea, right? The whole idea behind the correctional system is that you're supposed to correct the behavior, reduce the likelihood they will reoffend. There has been no decline in juvenile crime after transfer laws came into effect. And in fact, some research suggests that housing juveniles with adult criminals may promote criminal attitudes and motivations rather than doing the opposite. So higher rates of recidivism, reoffending, have been observed when youth are transferred. And juveniles in adult facilities were more likely to be sexually and physically assaulted than youth in the juvenile facility. So in addition to, like not helping them, we might potentially be putting them in harm's way. Juvenile transfer may also occur in the other direction. So juveniles that are placed in adult court can be reverted to juvenile court. And this procedure has been called reverse transfer. And some 25 states currently have reverse transfer procedures that basically you get up to criminal court and the criminal judge is just like, no, like, I don't understand why this case is here. This should be tried in juvenile court. So 25 states, half the states have reverse transfer procedures that allow juveniles in adult court to petition for transfer back to juvenile court. So it is an option for those folks. Alrighty, so that is all that I have for today. I will do my typical sticking around for a few minutes to see if anybody has questions. And actually, if you could all stick around for a couple minutes, I just want to make sure get everybody on attendance who may have come in a little bit later. There's a couple people that I missed already. Okay. Good question. Yes, the self-evaluation, I'm going to send that out over email tonight. Thank you, Tacey, for reminding me of that. I'm actually just going to write that on my hand. And it's just a Google form you fill out to evaluate yourself. And then I assign you your grade based on my agreement with that. So thank you, Tacey, for reminding me. I've been meaning to send it over the course of the last week and have obviously kept forgetting.
Dr.
Oh, go ahead.
If we are using a previous internship, because you had given us the midterm evaluations for that one, so can we just resubmit that as our thing, or do you want us to do this new midterm evaluation?
This will be your evaluation for participation during class.
Oh, okay. I'm sorry. I thought this was for the.
Oh, good. Yep. Well, it's not clear. There's a lot of evaluation. Yep. So this will be self-ranking for class participation, and you should include the chat, and you should also include what you all do in your breakout rooms. So. Alrighty. Well, have a good weekend, everybody. And I will see some of you before then, but everybody next Tuesday.
Dr. Myers,
Mhm.
I work late this evening. I did start some of the midterm, but if I don't get it in by 11:59, is that okay?
Oh yeah, yeah. I'm taking. You might have not been here quite when I was discussing it, but I'm taking everything right this grade that we did it on time.
Okay, cool. Cause yeah. Thank you.
No problem.
Yeah, my brain has been mush lately.